I'm Julia Sebutinde, showing you where development is happening. Please come and join us. Who is Julia Sebutinde, the only ICJ judge to oppose all measures against Israel? The Ugandan justice even voted against the charges that Israel's own justice, Aharon Barak, voted yes on. Julia Sebutinde, Uganda's representative to the International Court of Justice, ICJ, has become a hero amongst Israel supporters, though her country distanced itself from her. She was among the 17 judges who deliberated on interim measures in the case concerning the application of the convention in the Gaza Strip, South Africa versus Israel, on Friday. She uniquely voted against all proposed provisional measures, standing out as the sole permanent judge to do so, in contrast to ad hoc judge Aharon Barak, who opposed most but supported two Defiant ICJ judge says Israel-Gaza war is political, has no place in world court. South Africa has not demonstrated that Israel's acts in Gaza were committed with the necessary idle intent to fall under the convention, said Judge Julia Sebutinde in a minority opinion submitted to the UN's top court. The International Court of Justice in The Hague rejected South Africa's request to order a ceasefire in the Gaza Strip on Friday, but with the majority consensus of 17 judges, several interim measures were issued that called on Israel to allow humanitarian aid to enter Gaza and punish those inciting to hostile acts. Judge Julia Sebutinde of Uganda, however, was the only judge who voted against all 6 emergency measures adopted by the court, alongside the Israeli representative to the judicial panel, former president of the Israeli Supreme Court Aharon Barak, who also opposed most of the measures. In her minority opinion on South Africa's petition against Israel, Sebutinde wrote that the controversy or dispute between the State of Israel and the people of Palestine is essentially and historically a political or territorial, and, dare I say, ideological one. According to the dissenting judge, this dispute calls not only for a diplomatic or negotiated settlement, but also for the implementation in good faith of all relevant Security Council resolutions by all parties concerned, with a view to finding a permanent solution whereby the Israeli and Palestinian peoples can peacefully coexist. Sebutinde added that South Africa has not demonstrated, even on a prima facie basis, that the acts allegedly committed by Israel were committed with the necessary idle intent and that, as a result, they are capable of falling within the scope of the Side Convention. Unfortunately, the failure, reluctance or inability of states to resolve political controversies such as this one through effective diplomacy or negotiations may sometimes lead them to resort to a pretextual invocation of treaties like convention. Sebutinde continued, in a desperate bid to force a case into the context of such a treaty, in order to foster its judicial settlement. The judge likened this failure to resolve political disputes such as the Israeli-Palestinian conflict to the proverbial Cinderella's glass slipper. After Sebutinde published her minority opinion, Uganda's ambassador to the UN, Aharon Barak, stated that Sebutinde's position does not represent the government of Uganda's position on the situation in Palestine. Has previously voted against Uganda's case on the Democratic Republic of the Congo. Uganda's support for the plight of the Palestinian people has been expressed through Uganda's voting pattern at the United Nations. Aharon Barak added in a post on X. Sebutinde, a respected jurist in Uganda, was born in Entebbe in 1954 and is currently serving in her second term as a judge at The Hague. She was first appointed to the World Court in February 2012, and was re-elected in 2021. She is the first African woman to serve as a judge at the court. Prior to her role at the World Court, Sebutinde was appointed as a judge in Uganda's High Court in 1966, the third highest court in the country's legal hierarchy. She reportedly led a series of corruption investigations into government departments during her tenure, including into the Ugandan police and military. She was appointed as a judge at the UN's Special Tribunal for War Crimes in Sierra Leone in 2005, which was established to prosecute those who violated international humanitarian law during the country's civil war. She was also appointed chief judge in the trial of Liberian dictator Charles Taylor, who was convicted of 11 counts of war crimes and crimes against humanity in 2012. Taylor was the first head of state to be convicted under international law since World War II. The International Court of Justice, also called the World Court, is the only international court that adjudicates general disputes between nations and gives advisory opinions on international legal issues. It is one of the 6 organs of the United Nations, UN, and is located in The Hague, Netherlands. The ICJ is the successor of the Permanent Court of International Justice, PCIJ, which was established in 1920 by the League of Nations. After the Second World War, the League and the PCIJ were replaced by the United Nations and ICJ, respectively. The statute of the ICJ, which sets forth its purpose and structure, draws heavily from that of its predecessor, whose decisions remain valid. All member states of the UN are party to the ICJ statute and may initiate contentious legal cases. However, advisory proceedings may only be submitted by certain UN organs and agencies. The ICJ consists of a panel of 15 judges elected by the UN General Assembly and Security Council for 9-year terms. No more than 1 judge of each nationality may be represented on court at the same time, and judges collectively must reflect the principal civilizations and legal systems of the world. Seated in the Peace Palace in The Hague, Netherlands, the ICJ is the only principal UN organ not located in New York City. Its official working languages are English and French. Since the entry of its first case on the 22nd of May 1947, the ICJ has entertained 191 cases through the 13th of November 2023. Pursuant to Article 59 of the Statute of the International Court of Justice, the court's rulings and opinions are binding on the parties with respect to the particular case ruled on by the court. The first permanent institution established for the purpose of settling international disputes was the Permanent Court of Arbitration, PCA, which was created by the Hague Peace Conference of 1899. Initiated by the Russian Tsar Nicholas II, the conference involved all the world's major powers, as well as several smaller states, and resulted in the first multilateral treaties concerned with the conduct of warfare. Among these was the Convention for the Pacific Settlement of International Disputes. This is the end of our program today. See you on Intervlog same time tomorrow. Thanks for watching. Please like and subscribe to my channel and press the bell icon to get new video updates. Thank you for watching Intervlog. Thank you.